we have read the briefs. We are ready to proceed when you are. Please do not use the names of any victims or minors. This argument is being recorded and will be posted on our website.
Okay. You ready?
Yes.
Thank you, Your Honors. May it please the Court, Attorney Angie Killey on behalf of the appellee, Percy Roberts. The question for the Court's consideration today is whether the trial court erred or abused its discretion by dismissing the indictment with prejudice in this case. This transcript really consists of one hearing on December the 6th, 2021, and in reviewing the state's brief as well as the applicable law under Criminal Rule 48, I don't think there's much of a disagreement as to what the law is. I don't even feel that the trial court had a disagreement as to what the law said. And the state, in their brief, made a big argument out of the fact that you couldn't dismiss with prejudice over the state's objection without, quote, a deprivation of the defendant's constitutional or statutory rights, a violation of which would bar further prosecution. However, the trial court clearly considered that in making the decision that she made because she cited that and said that she did not find that. The state argues that her reliance on a precedent from out of this district, non-binding, although persuasive, was where she abused her discretion, and we would respectfully disagree with that. The court relied on State versus Malone, and we are asking this court to follow that, feeling that it is not an abuse of the discretion for the trial court to have felt that that was the appropriate remedy, in which there was essentially a dismissal with prejudice over objection as a result of a plea bargain. And I know there's an argument to be made that there's no plea bargain in a case where the charge is dismissed. However, it's still bargaining. It's the essence of, is what they talk about in the Malone case. The policy is rooted in the same due process concept, regardless of whether or not it is a dismissal or there's actually a plea that results in that. And like the case in Malone, in this case, there was bargaining that took place between the defense and the prosecutor. Very clearly bargaining. The defendant in this case actually executed an affidavit or a legal document revoking a power of attorney that he had in place. And his doing that was the basis of the state moving to dismiss. In addition to that, although the court acknowledged that they really didn't have the authority, he agreed to no contact. So we have two very significant agreements by the defense as part of the basis for them agreeing to dismiss. So it's our position, and the trial court was correct in that this is factually similar to Malone. And it would be my opinion that part of the reason the state objected to this is that they're afraid that this is going to create this wave of dismissals with prejudice that override their discretion when they're doing this pursuant to the criminal rules. But the reality of the situation, I think, is a very fact-specific situation in that it's kind of, in these circumstances where there is some consideration, there is some bargaining, that the trial court has the authority to do that as opposed to in any and all circumstances. However, if the court were to disagree that this case is factually similar to Malone and that that would be good case law to follow, then it's our position that 48B would have granted the trial court the authority to dismiss this with prejudice as well. As I'm sure the court's aware, 48B does allow the trial court to do a sua sponte dismissal, and under those circumstances, the rule simply, the reasoning for that is not enunciated in the rule, it's done through case law, and what the case law says is that the court would have to put a factual basis in their decision for why they felt that it was appropriate to dismiss the case, and in this instance, the trial judge did that. She specifically put in her ruling that part of the reason for her dismissal with prejudice was because there were plea negotiations, the case had been pending for 2 years, and that the state lacked the evidence to proceed, which I think is pretty compelling reason for a case to be dismissed. So our position would be that the trial court was correct, but even if the court feels as though that law is not applicable in this jurisdiction, we still feel that the trial court was correct in the decision that she made, and it's definitely, we don't feel that it rises to what is called an abuse of discretion, because it's pretty clear from the journal entry that the court did give this some very serious thought, took the facts and circumstances of this specific case into consideration when issuing the decision that she did to dismiss it with prejudice.
assuming that the case law is very persuasive that the judge could do this at the trial court level. Explain what the bargain was if it was an unenforceable promise to stay away from the victim and the revocation of the power of attorney was it the power of attorney over the victim?
The alleged victim, yes.
The alleged, thank you. This individual having the power to revoke a power of attorney herself, or was there no ability of the alleged victim to revoke that power of attorney? I'm just wondering what the bargain is.
I think the primary bargain is the revocation of the power of attorney, and I'm not going to pretend I'm an expert in power of attorney law, but I think that there may have been, the impression I got not being trial counsel is that there may have been some questions as to the competence of the alleged victim in this instance, which I would say puts her in a category that she could not revoke that of her own volition, in which case, him executing documentation that he is revoking it, walking away from this that was properly executed at the time is a benefit.
So we will find some of that discussion in the record regarding the benefit of the bargain that was made.
Yeah, there was a little bit of discussion. Honestly, the record was lacking a little bit because it was a pretty quick little hearing about what was actually taking place, but the impression that I got through my review is that we were talking about an elderly person who is alleged to have been being taken advantage of. So I think that there would have been a question as to whether she would be able to do that herself.
Understood. Thank you, counsel. Any other questions?
And if there's no other questions, then I'll rest on my brief.
Thank you very much for your presentation today. As you know, we will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal.